Hi, Assalamualaikum. Today we want to present about caveat and its legal issues, and this is our group members. Okay, the parts of the story we divide by three: the beginning, middle, and end.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Aidil bin Kasim. Number metric AP 200Y2 will be present for the abstract. This article reports the result of two studies aimed at caveat and legal issue and refining procedures for estimating two kinds of restraint on dealing for the caveat and prohibitor orders to contingent in respect of land. In spite of fact, the respondents were given opportunity to discuss various safety, prohibiting the judgment debtor from effecting any dealing of safety estimated using conventional contingent in caveat and legal issue procedures.
A caveat is defined as lodged and then entered on a register not registered, as in the case of transactions. Defect has arisen, then the parties involved and the prosecuted have to find a way to safeguard their respective interests. It is also understood to mean caveat is a simple and inexpensive management tool provided by the National Land Court to protect the interests of certain parties. Moreover, caveat divided into four types. The first is registered caveat, means the caveat entered or registered by the land register on the title document. And the second is privacy caveat, then can be entered by an individual or private body having an interest in a particular pieces of land. And the third is caveat of the holder or lien, entered by the individual that holds the title document as collateral for a specific purpose, such as the granting of a loan such as bank. And the last type is trust caveat, only entered by the register against any lands or interests owned by an individual or body as a trustee. For example, once a caveat has been registered on a property, the registered owner no longer has the authority to perform any transactions on the land until the time of the caveat expires. Any sale and purchasing of land, such as selling, mortgaging, renting, or transferring ownership of land until the time the caveat expires.
I will continue this presentation with present about general provision. First, who has the authority to file a caveat? A caveat can be submitted by any party whether or not the person is a party to the claim. It is as long as the party who files the caveat has the right to appear in court in connection with the suit. Second, when should you file a caveat? First, people have the right to file a caveat under 148A if they believe the case against them has been or will be brought in any court of law. The caveat can be brought as a petition in the following circumstances, which is first, while a suit or litigation is pending and an application has been submitted or is likely to be filed. Second, a lawsuit is soon to be filed and an application will almost certainly be filed in that case. Next, how does a caveat work? First, application for entry of a private caveat. Form 19B of the National Land Court is used to submit a caveat. All the following information on this form must be filled out first, which is name of the registrar, your own personal name, your claim to the land, fees that are relevant, the proprietor's known address, signature and date, witness and signature, and lastly, details of the land and property caveat to be logged against. The common mistakes made when filling a caveat are: first, caveat are after filling in support of an application. It has been emphasized that caveat can be made only against an application. Second, the caveator forgot to serve the notice on the applicant, which is mandatory under Section 148A of the CPC. And lastly, caveator often claim that the order or judgment was incorrect because notice was given even after the period expired. It is already clarified that after 90 days, a new caveat needs to be filed. In addition, to begin a private caveat may be removed at any time by submitting from Form 19C on the NLC to the registrar. For a registrar caveat, it has no expiration date and stays in effect for the duration of the registrar property caveat. A license holder caveat, on the other hand, will not expire after 6 years. The caveat will only be lifted as the property has been sold and the sale has been recorded. Finally, the trust caveat will remain in effect until the registrar cancels it in response to a joint application by the trustees and beneficiaries.
Let's look the middle part, that is the discussion of the cases. Okay, the first cases is between the Caro Piacere versus the Subramaniam. Let's look the summary for the cases. The purchaser had paid the full purchase price to the land to the vendor, who had then executed a transfer in the statutory form but had not surrendered the issued document of the title to the purchaser. Then the purchaser subsequently had lodged private caveat to protect his interest in the land. Okay, the federal court held that the purchaser, having entered the caveat, has priority over a claim of the judgment creditor who subsequently had entered in the prohibitory order against to the land. Okay, let's look. The second cases is between Meccan Engineers Sdn Bhd versus Goh Hui Yen. Let's look the summary for the cases. The respondent had lodged a private caveat pursuant to an agreement in writing whereby he had agreed to purchase a property from the vendors. Then the respondent had paid a deposit toward a purchase price, the balance to be paid on or before the stipulated date. Then the dispute arose regarding the completion of purchase and the vendor sought to determine the agreement and forfeits the deposit. Consequently, the appellant applied to the court for the removal of the caveat. Held for these cases is dismissing the appeal, that is, it will seem abundantly clear from the authorities that so long as there is existence a valid agreement for the sale of land, the purchaser is entitled to lodge a caveat to protect his right under the contract and to sue for specific performance of the agreement.
One for the third case, Makon Works and Trading Sdn Bhd versus Fang On Su. Okay. That the whole system or the caveat is founded on the principle that they exist for the protection of illegal as well as proven interest. The how for this case is first, the option was void for lack of consideration. Second, as far as the National Land Court is concerned, the whole system of caveat founded on the principle that they exist for the protection of legal as well as proven interest. In this case, no action had been taken by the defendant to remove the caveat on the ground that the plaintiff had no interest in the terms of National Land Court 1965 for capacity to lodge the caveat. That's it.
Okay, based on the slide, for case between an Vegedasalam versus Mahadevan and Anwar, Federal Court was faced with the question whether a person who is interested in only a specific portion of the land has a caveatable interest to support a private caveat. As we know, private caveat does not have the effect of changing the caveator's interest in the land, and it also does not create a legal interest in the land. See side Agi Barakpah observation in Damodaran versus Vasudeva. No person can create right in his own favor, nor enlarge or add to his existing property right by means of caveat. Sufyan Alfi heard that such a purchase a caveat provided that he limits the effect of his caveat to cover only the particular interest claim. Based on the last case between Mok Yong Kon and Anor versus Mok Yong Chuan. In 1975, he transferred his one-party share to his brother, the first appellant. This transfer was done pursuant to an agreement or understanding between the brothers. Under the agreement or understanding, the one-party share was be transferred to the respondent after the subject property has been used to raise funds. On 2 June 1997, the respondent lodged a caveat. This appeal was directed against the order of the High Court, dismissing the appellant application to remove the respondent's caveat. 8. There was no allegation was offer made against the second appellant, the registered proprietor of the subject property at the material time the respondent caveat was lodged. The caveat was labeled to be removed on this count alone as being frivolous and litigious.
I will continue for the conclusion. Lastly, conclusion for the caveat generally all dealings and interests in land should be registered. There may be certain interests in land which are not capable of being registered. These non-registerable interests are protected under the Land Code 1965, which allow them to be noted on the register in some manner short of registration. This is illustrated by the caveat system. Private caveats are by far the most frequently used and form a substantial part of the conveyancing work of solicitors, and for the reason the greater bulk of case law deals with type of caveat, the duration of each type of caveat also differs. Thus, wills private caveat will lapse according to section 3 to 8 after 6 years unless withdrawn much earlier by caveator under section 235 or removed by under the register under section 326 or by under the court under section 327. The other caveat have longer and identifiably life span. That's all from me. Thank you.
That's all from our group. Thank you.